You have two members that own a business. There's a number of different satellite businesses that relate back to the ultimate owner of the original company. And one member is a 51% member. The other member is a 49% owner. The 49% owner is operating the satellite office that's located in Westchester. In the Westchester office, there's a number of different customers that are constantly coming in. A lot of sales get made, a voluminous amount of sales daily. And there's technology and computer software that's utilized daily in order to ensure that those sales can be made. And these sales are very time sensitive. They're very important. And any loss in the ability to move matters along could actually result in very severe damages. The majority member of the company and the minority member who's running the Westchester office get into a feud. The dispute only worsens over time. The relationship gets to the point that it's breaking down and breaking down. The majority member then decides to do a few things that weren't prudent. Number one, the majority member locks the minority member out of the company bank account. Then, after that, the minority member walks into the Westchester office and all of that software technology gets shut down. Within 24 hours, the internet at the location is then shut down. Then the minority member comes to hear that all of the customers that were going to this Westchester office were being called by the New York City office, where the majority member had a company, and they're saying that the Westchester office is permanently closed, but come to our new facility, which is located downtown in the financial district. The original main company office was Midtown. Minority owner gets word and says immediately, we need to file suit. And that's exactly what we did. Claims for fraud, unjust enrichment, fiduciary breaches, usurpation, corporate, everything you can name of gets filed. But here's the thing, that wasn't enough to protect this minority member, because the reality is the majority member utilized a new entity that he had opened to open up the downtown office and divert all the customers to go somewhere else. So this minority member was stuck in a position where if we don't get an order to show cause or some ability to, number one, perform operations, and number two, get the majority member's office from stopping to call all the customers telling them to go to this downtown office, there was going to be a complete loss of reputation, the ability to work, the ability to earn. It was going to be off. So we had to run into court and file what's called an order to show cause for emergency relief. And that emergency relief was a temporary restraining order to, number one, enjoin this party member from calling any further customers to say that the office was closed. Number two, the order also needed to obtain language that said that the technology had to be restored. And number three, the majority member was also required to restore the internet at the location. We were able to do that within 24 to 48 hours. A temporary restraining order is something that you get when you file all these documents, you run into court and you get that TRO. Within then, usually the judge has the parties come back within 2 to 3 weeks, where the judge gets an opportunity to review the full briefs of each party and decide whether or not this TRO is going to extend throughout the duration of the litigation. If the answer is yes, then it becomes a preliminary injunction. If the answer is no, then it gets dropped. Ultimately, in that case, we were able to secure the preliminary injunction predominantly because, absent that immediate emergency relief, our client was going to have no rights, so that if we got a judgment a year and a half, 2 years later, and out of luck, customers would have all been gone, would have had no ability to collect revenue, the business would have been destroyed. Whether or not I need to seek additional relief immediately all comes down to if you believe that if you don't seek that relief, your company is going to be rendered worthless. If you have any other questions, you can email us. You can email me directly at ross@pitcofflawgroup.com. Shoot me a note on LinkedIn or Facebook, any social platform you're watching this on. You can send us an email, info@pitcofflawgroup.com or ross@pitcofflawgroup. And if you have a topic you're interested in hearing about, shoot us a note. We're really curious to hear what are your concerns or questions you would have, and we're happy to deep dive into something and kind of unpack it in a way that's valuable.